statute does not limit the Secretary's inherent authority to reconsider any TPS-related determination, and upon reconsideration to change the determination.
Right, well, that's one Secretary's interpretation of the statute, maybe right, maybe wrong.
Let me ask, it's both Secretary's interpretation of the statute.
Well, there's two of them. On the other hand, we've got the statute, and doesn't, even as a matter of statutory interpretation, putting aside whether this is a workaround or not, where a statute sets forth temporal expectations and time blocks and has specific markers, doesn't that suggest that an agency can't use whatever implicit authority to contravene that? That is, to do something. It is contemplated that there are clear time markers set forth in the TPS statute, and to take actions that effectively shorten the time seems like that's something that's not within the power of the agency to do once Congress had set forth temporal expectations and markers.
Well, I will note that the extension hadn't gone into effect. If you look at the language of the extension itself, it says this goes into effect on April 3rd. And so that is the decision that the Secretary is reviewing and reconsidering. The vacature had already gone into effect, but the extension had not. And so I go back to the statement that an extension, these individuals before, I'm getting all confused. The April 2nd deadline was one that individuals who had registered for TPS under 2023, under the 23 designation, they understood that to be the end of TPS. So then we have the 10-day period where Mayorkas extends, but we can't ignore the fact that a new administration is coming shortly thereafter. And so I think those 10 days to 2 weeks and the reliance interest there, and Secretary Noem recognizes that. That's overcome by what she finds to be the national interest concerns that she points out in her termination.
All right, let me hear the response to the argument that there was no violation of the statute, the time frame of the statute, since this was a vacator and the Secretary gave herself time before making a termination decision. So it's not synonymous, and also the argument that there was the extension by Secretary Mayorkas was not effective, and therefore I guess the argument is there was no real termination.
Thank you. Good morning, Your Honor. Jessica Bunsell.
Yes.
To begin with the argument that because the vacatur was made within a 60-day period, it somehow didn't violate the fixed time terms of the TPS statute. Your Honor, that's incorrect. Under the statute, subsection B3B, that says that a termination cannot take effect earlier than 60 days after publication of the termination notice, or if later, the expiration of the most recent previous extension. And so when Secretary Mayorkas determined on January 17th that the conditions for Venezuela's TPS designation continued to be met, that determination under the statute triggered an extension. The extension flowed from that determination. And once that extension was on the books, this fixed time period set forth in the statute controls when a termination can take effect.
So which section do you cite for the proposition that once the determination by Secretary Mayorkas was made, that triggered the extension at that point?
Your Honor, in subsection B3C of the statute provides that if the Attorney General does not determine that the foreign state no longer meets the conditions, and so on January 17th, Secretary Mayorkas determined that not only did it no longer meet the conditions. He made an affirmative determination that conditions continued to be met. Under the statute, the period of designation of the foreign state is extended. If you look in the January 17th notice also, Your Honor, we disagree that that notice was not effective until April 3rd. The extension of work permits and lawful status began on April 3rd, but that January 17th notice says that TPS holders, for example, can show that notice to their employers with their EAD with that April 2nd expiration date as of January 17th, and the employer can take that to mean that their employment authorization is extended. It also opened registration to apply to extend your TPS through October 2nd, 2026 on January 17th. So that notice did take effect immediately, both under the statute and by its own terms, Your Honor.
And then, I guess that stands in contrast to Part B, which is termination that has time deadlines. There's a sort of breathing period. That is, you have to give at least 60 days notice before it's effective, or if later the expiration of the previous extension period, whereas subsection C regarding the extension of a designation is simply is extended. It doesn't say 60 days later, etc.
That's correct, Your Honor. The extension is effective immediately. Another point I'll make is that the TPS holders who are covered under the 2023 extension, my friend opposing counsel said that they knew their TPS would end on April 2nd. That's not correct. They knew that a new decision was required within 60 days before April 2nd, and they knew what conditions in Venezuela were, and so they knew a new decision would be coming, but they weren't anticipating. There wasn't a termination of Venezuela that was set to take effect at that time.
Right. What about the other argument that there was not a termination, that this was a vacator?
First, Your Honor, under Gorbach, the en banc Ninth Circuit decision in Gorbach and China Unicom just a few months ago, as Your Honor stated, where a statute provides a specific process to alter an authorization, here the designation, that negates an assertion of.
I'm sorry, say it again.
Where a statute provides a specific process to alter the designation, that negates an assertion of implied agency authority. I just also mentioned that, as Your Honor mentioned, neither of those cases discuss the TPS statute, but Gorbach does address one other statutory provision the government points to, which is 8 U.S.C. 1103A, the sort of broad enabling statute that sets forth the Secretary's powers and responsibilities. And they say that that is not a source of implicit reconsideration authority, and that because in Gorbach, the question was whether the Attorney General had authority to denaturalize a person where she had evidence that the naturalization was based on a fraud or material misrepresentation, and the court said no, because the statute sets forth a process for denaturalization, and that exhausts the field. Similarly here, Your Honor, the TPS statute has a process for altering a TPS designation, and that's inconsistent. That process is inconsistent with an assertion of implicit authority to reconsider. And the fixed time period also is another
When you say
separate factor.
the process, that's the process for the periodic review?
Yes, Your Honor, the process in subsection B3 of the statute, the periodic review. It says when the decision has to be made, it requires consultation, it says how and when the decision has to be published, it says the bases, the permissible bases for a decision, and it says what the options are, and the options are to extend or to terminate, Your Honor. There is no vacatur. Under Gorbach and China Unicom, that process exhausts the field, and that process negates an assertion of implied agency reconsideration authority. We also cite, Your Honor, a DC Circuit case that involves a similar statutory scheme from 2023. It's NRDC versus Reagan. That was a case that addressed whether the EPA had authority to reconsider its determination that a certain contaminant in drinking water should be regulated. It's similar because the EPA there had a lot of discretion at the outset to determine whether regulation was appropriate, But once it made that determination, it triggered certain things under the statute. And so the court held to allow the EPA to reconsider its determination, just wipe it from the books, contravene the statute, because under the statute, the determination triggered, certain things flowed from that. The same with the TPS statute, Your Honor. Secretary Mayorkas's determination that conditions for the designation continued to be met triggered an extension, and under the statute, TPS could not be terminated before the expiration date for that extension. So to allow the vacatur here would contravene both those protections in the statute.
And what's your response to the argument? We're going to need to take a break here in a moment because the court reporter's been going at it, but what's your response to the need, if an emergency arises, a national emergency arises, that the government and the secretary needs flexibility, and that's why one should imply some additional authority beyond that that's prescribed in the TPS statute? What's your response to that?
A few things, Your Honor. One is that Congress has provided a means in the TPS statute for the secretary to address national security issues. And it is not to vacate a TPS extension for 600,000 people. Under subsection C2B, if the secretary determines there are reasonable grounds to regard an individual as a danger to the security of the United States, that individual is not eligible for TPS, and that individual's TPS may be withdrawn. That's the mechanism Congress has provided to the secretary. The second point I would say, Your Honor, is that if you look at the vacatur and the government's arguments in the brief, the vacatur, as you noted, is based on alleged problems with the filing process. Vacatur is not based on national security issues. And the last point I'd make, Your Honor, is that China Unicom, which sets forth this rule that where the statute has a specific procedure that exhausts the field, that's a case where the agency was asserting reconsideration authority based on national security grounds. And so there's not a different rule in that context. Even if the agency is asserting national security or some other important interest, they still have to follow the law.
All right, let me give you a brief chance, and then we're going to take a break, and I'm going to continue after we give a court reporter a chance here.
Sure, Your Honor. I do want to go back and note that the extension itself explicitly says that it doesn't go into effect until April 3rd, 2025. So I understand plaintiffs would like for it to have gone into effect immediately, but the language itself in the FRN explicitly gives the effective date. And just because it allows people to re-register, that makes sense as a practical matter so that there would be no break in their employment authorization documents.
What does effective date mean? Does that mean that because there was already a designation extension that this
Correct.
becomes, it doesn't mean that it doesn't have any operative effect?
It has operative effect, but it's not going to do anything until April 3rd. People can re-register and they can have their employment documents teed up so that they can continue working, but that extension, it doesn't go into effect until April 3rd.
So you're saying that at the very least, the secretary has the ability to vacate an action if it's not in effect at the time of the vacatur?
Yes, Your Honor.
And is there a case law that draws that distinction, that keys it to the effective date?
Not that I'm aware of, but that is also what Secretary Mayorkas relied upon when he vacated the termination decisions. I would also point out that it is contrary to the statute to say that a secretary cannot come in and look and determine if there's a national interest concern.
Well, it can, but it does so in the process of designating, whether or not a TPS status is warranted under subsection C.
Well, and different administrations are permitted to come in with different goals and different policies as long as they're within the confines of the statute. And here, the statute provides a periodic review. So the idea that the secretary would have to wait a year and a half before she could make what she feels is a concerning decision against the national interests of the United States is contrary to what the language of the statute itself says.
Well, I'm not so sure about that. The language of the statute says, even considering where TPS status is granted in part because of concerns about national interests. By the way, it says national interests. I'm not sure how that's different from national security, but national interests of the United States.
Yes.
It still says that to terminate, you've got to follow 3B. And there was no exception to say, well, if the designation is made under B1C in the national interests and that can be advanced or something. There's nothing that says that.
I'm sorry, could you say that again?
Nothing in the statute allows an advancement of the termination right where the designation is based on B1C, national interests. It makes no distinction. It just says you've got to do it, during these periodic reviews, et cetera, et cetera.
Correct, Your Honor. That's why we argued that it's inherent in the statute. It's not explicit in the statute.
All right. When we come back, I do want to address the reasons for the vacator and the question of whether there's a review of that, assuming that that there is authority to vacate. I think the secondary argument is that it was still wrongful to do it. Obviously, if I were to find, as a matter of statutory construction, that there was no power, we don't need to reach that question. And then I do want to address the equal protection matter. So we'll take a 15-minute break. Our reporter's been going at it. Thank you.
Court is in recess.